Okay, let's get into lesson one of Intro to Criminal Justice. So, the first thing that they talk about is a lot of some terminology, and I think that really the first lesson we're really trying to lay a foundation in terminology to make sure you understand what exactly throughout the rest of the semester what exactly they're talking about. So you look at terms like what is criminal justice and all these other things. For instance, what is criminology? And in the future, you will probably end up taking a course called criminology. And so, what does that mean? And so, in terms like that are important. So, for instance, criminology is the scientific study of the cause and prevention of crime and the rehabilitation and punishment of offenders. So criminology is almost like the psychology of criminal justice, the psychology side of it. Why are offenders thinking the way that they think? Why are they doing things the way they do things? And it's kind of our own little psychology specialty that we have within the criminal justice field. And criminologists can have many different forms. You can have some of the criminologists that you see on TV that are like trying to almost like profilers. They're trying to decide why something happened. But you can also have the reverse side of that. You can have criminologists who are on the prison side of things, who are trying to determine, what can we do in criminal justice to change to rehabilitate offenders. So you have criminologists who are trying to catch criminals and criminologists who are trying to make criminals better, And so criminology, when you hear that term going around, just think about psychology of criminal justice almost. Then they go into some terms like things like what is a consecutive prison sentence, compared to a concurrent prison sentence. So like a consecutive prison sentence is basically when you're found guilty of two different crimes, and they say that your sentence is going to run consecutively. That means when you get done serving your sentence for this, then your time starts for this. So if you get 12 years for this offense and 6 years for this offense, you don't get done with your 6 years and only have 6 years left. You get done with your 6 years and have 12 years left. Whereas if it was running concurrent, then obviously the highest number of years wins. But if you got 6 and 12, then you're only going to serve 12 years. So it gets into some things like that. And why is that important to notice is that when you're starting to talk the criminal justice lingo or the criminal justice jargon, it's important to know things. So when you hear somebody throw out the words, he has a consecutive sentence, you know that this person is going to be in jail for this amount of time. It's important to know, especially if you get into a field like probation and parole and things like that. As you go in and start studying these areas of criminal justice, you need to know things like this. You need to know things like what an arraignment is. So let's talk about that. I mean, you kind of see it on Law and Order and some of those other shows. But arraignment is really where you go in and you plead guilty or not guilty. Now that doesn't always happen. There's other things that can happen at arraignments. Sometimes the judge just simply says, I'm not letting you, even if you would, sometimes when you go into an arraignment, I've seen this happen. Someone goes into an arraignment for a serious charge and say, I'm going to plead guilty to this. The judge will not accept their guilty plea. He says, I'm assigning a court, attorney, a public defender to you. Also, this might be the time when someone says, I want to plead not guilty by reason of insanity. But this is the time when the person can produce their plea. It's different than the booking time, right? So the booking time can happen much before the arraignment happens, right? So you can be booked and not be arraigned immediately. Now, every state's different. Right now, I work at a state where the arraignment has to happen like that. But when I was in Ohio, you had some time before the arraignment happened, If I put someone in jail on a Friday and the judge wasn't in, then they got arraigned on Monday. In fact, a lot of cops would think it was somewhat comical when they had a violent offender that they would put in on a Friday night, but Monday was a holiday, so the arraignment wouldn't happen until Tuesday. The jurisdiction I'm in is not like that. They have a judge on call, and they call the judge in right there, and the person's arraigned. But booking, that's when you're just getting your mug shots, your fingerprints, and stuff like that. The judge never sees you. You have nothing to do with the arraignment. Arraignment is when the actual formal charge is read to you, and you have your opportunity to say guilty or not guilty. All those are different than the preliminary hearing, which comes next. And we call it the prelim a lot of times. And so what happens in that preliminary hearing is that's an opportunity kind of when we start deciding what can and can't be heard. and if and a lot of times a judge will decide in that preliminary hearing if there's enough evidence that we have to proceed with the case. What the defense attorney is trying to do is say, hey, look, Your Honor, they don't have enough evidence. They don't, and he's trying to line up his ducks in a row and say, listen, they don't have this, and this, and so they don't have enough to proceed with the case. And the judge's job in that case is to save the court's time, to not require, not allow the prosecution to go further with what would be called what would be considered almost like a frivolous trial. So that's an opportunity for the defense attorney to do that, to get things thrown out. Sometimes in the prelim, you'll have them challenge evidence. You'll have them challenge a DUI. Like during a DUI, a prelim for a DUI, he might review the video footage and say that this was done incorrect, and that's the time when the judge will determine that. So a lot of these things that you maybe see in court that they're arguing about during a trial really are handled in the prelim in the real world. But then what is interesting is then we get into the Fifth Amendment to the Constitution of the United States, which is due process. And so due process, sometimes it's easier sometimes to equate due process in the workforce than to equate it in the law. So when you think about due process, it applies in your workforce. Most places, they don't just walk in and say, you know what, I don't really like you today, I'm going to fire you. There's a process that they have to follow. A written warning, or a verbal warning, then a written warning, then a 1-day suspension, then a 3-day suspension, then a 30-day suspension, and then a termination. There's a step process. Sometimes people call it progressive discipline. There's a step process in order to get to termination. You have to do the due process and follow these rules to get to that point. And that's what they're talking about with due process. The same way with the court. You have to go through these steps. You have to have their booking. You have to have their arraignment. You have to have all these steps to have due process. It makes it fair. It's a procedural fairness within the court system. I also want to make sure you understand what an indictment is and some of the purposes for an indictment, because a lot of people don't understand why would we have the grand jury hand down an indictment as opposed to allowing the police officers charge someone. And there's a lot of reasons for that, a lot of advantages for it. But I'll just say one is political. If a prosecutor charges someone with murder, and then the person is the murder charge through the court process is dismissed, the person gets off with it, whatever. It's easier for the prosecutor to say, whoa, a grand jury did that. A group of 12 people filed those charges, not me. And so that's what an indictment is. It's different than a police officer filing the charges. The indictment is when the grand jury, a group of 12 or however many people that county has, a group of people hear what's going on and then hand down an indictment. Now, what's interesting about the grand jury is this isn't a prosecutor and a defense attorney. The defense or the defendant doesn't have any say normally during a grand jury. I've only seen one time where the defendant was allowed to testify. It's all one-sided. It's all the prosecutor he's putting in front of the grand jury, the police officers, he's putting in front of the grand jury, the experts, and not even the experts usually, because they don't need it, because he's leading this grand jury, this group of 12 people, or however many people it might be, 20, whatever it might be, this group of people in the direction he wants them to go. And then at the end of the day, he says, now, do you think we should charge this person? Well, normally the grand jury is going to say yes. Why? Because you've only showed them one side of the argument, and there was really no due process, because all we're dealing with here is just the initial charge. It's not the time for the person to defend themselves. The time for the person to defend themselves is in a trial, and in fact, the Sixth Amendment to the Constitution allows a person to have a jury trial. So why would you have a jury trial over a trial with a judge? And so that's the defendant's opportunity. They get to choose that. The Sixth Amendment allows them to choose that. Not in all cases. I mean, for a speeding ticket, you're not going to get a jury trial. Why? Because it doesn't have anything to do. It's not a criminal act. You're not going to go to jail over a speeding ticket. But for a criminal offense, for being charged and you have the penalty in jail time, looming over you, then you're allowed to have this jury trial. And some people really believe that the judge trial is the way to go, especially in a case where there's some technical elements that the defense really doesn't think the prosecution has met, and so that's an opportunity for them to really make some holes. And the judge trial, having a judge trial with no jury, really is when you're trying to take the emotional element out of it, especially if you have a very gruesome crime, maybe, but there's some technicalities that you think you can get off on, where you don't think the prosecution has proven their case. That's what you're going for. Jury trial, obviously, if you think you can sway them, if you think that your case is so solid that you can leave it up to 12 people. The advantage to the jury trial for the defense is, of course, in a criminal case, you have to have all 12 agree with you, or you get off, or they have to have all 12 agree with them, or you get off. So if you can even just sway one person, then you're going to have a hung jury, and they're going to have to retry, which is something that doesn't happen that often. So it's something to think about. Why people are choosing that, why they're going that route. Much different than a civil case, where a civil case is proof beyond a preponderance of evidence, and you only have to sway the majority of the jury in your direction. A criminal case is proof beyond a reasonable doubt, and you have to sway all the jurors in your direction, unless you're the defense, and then in that case you only have to sway one, and then you get a hung jury. So those are some of the establishments, some of the baseline things that we're going to talk about. So I think that hits the main key points I wanted you to hear about this week. Shoot me an email if you got any questions. Have a great week, and good luck with your first week of the course.